Welcome. Should you lie to your lawyer in your own case? Today we explore why people do lie to their lawyers, the reasons for it, the benefits they seek to accomplish by it, and the results from that. My name is Matt Hamilton. I am a trial attorney. And like all trial attorneys, it's a regular feature where some clients will have a motivation to tell a lie to their own lawyer that later comes out. Well, why should one do this? In injury cases, for example, it is often the case that a person has a pre-existing condition, either a bad back, a functional problem with their hand, some sort of injury that they've accumulated during life. And then they get into an accident. And the accident oftentimes injured the weakest part of their body, a body part with a pre-existing problem. Well, they don't want to admit that. They think it has nothing to do with their case. And so why mention that to the lawyer? Why not just claim you were totally injury-free? It'll make the lawyer's life simpler. It'll make the lawyer more persuasive because he will believe you. And you'll have a higher case value. These are reasons people lie in injury cases. Take, for example, it's a motor vehicle accident, and the person wasn't wearing a seatbelt at the time when they should have. And they've learned that that can reduce their case value. Or they weren't driving as safely as they could have been. Or they were texting or on the phone or messing with the radio or talking with a passenger. So they were distracted. And they realized that this comparative fault is going to reduce their case value, add to the complexity, and it shouldn't, because that darn other driver was at fault totally and they shouldn't have to deal with it. Well, these are reasons they lie to their lawyer to keep the secrets out, so that the facts of their case are simpler and they have a higher case value. Or say it's a traffic case or a criminal case, and the person ordinarily didn't behave that way, and they're embarrassed by how they acted that day, so they don't want to admit it. And so they simply tell a lie saying, I don't want to admit to myself that I did that, and I certainly don't want to admit to others that I did that, and so I'm not going to. Or say there's a motivational factor and they think that the lawyer is going to be more persuasive, that the lawyer believes their story. Or it's going to increase their case value and it's really all about getting the money. Or they simply want to make the life as little more complicated as they can for their own lawyer. These are reasons why people would lie to their lawyer. Oftentimes with good motivation, sometimes with just very human motivation. This is almost always, 99.9% of the time, a mistake. And 100% of the time, it's a bad strategy. Let me explain. From the outgo, you've hired a lawyer that regularly practices in your field, in your location, that does that for a living. If you've done that, that lawyer is going to be one of the most persuasive people from his field. You're not going to have to motivate that person, your lawyer, to be more persuasive. You're not going to have to coach him up on ways to be persuasive. They're already there. So the lie to get persuasiveness from your lawyer is going to be ineffective. From the start, that lawyer is going to have a case strategy. And if you've told a lie, well, documents may come out, testimony may come out, issues will arise, and you will have created an improper case strategy. Remember, it's like the old computer days. If you put junk in, you'll get junk out. And that's the same thing with the lies versus the truth. The lawyer needs to know everything. He really does. Third, facts often emerge in cases. It is the strategy of the insurance company, and it is the strategy of the defense lawyers and the offense lawyers to always elicit all the facts that they can. And oftentimes they will commit you, the victim, to a very detailed accounting of exactly what happened. And then they'll go and investigate. They'll get all the documents from all the different sources, all the testimony from all the different sources. And if there is one discrepancy, they will focus on that and make it look worse. Guess what they're going to focus on? The one part that's the lie. And that's why the lie is a problem. You can't change other people's testimony. You can't make everyone more persuasive, and you can't hide documents that people already have. Next, the lie is often completely wasteful because the testimony or the evidence was not going to get in anyways. It is a common feature of every case for a lawyer to either file a motion to suppress or a motion in limine. These are pleas going straight to the court to keep evidence out of your trial. In almost every case, evidence is kept out of trial because it's irrelevant, or it's highly prejudicial, or it doesn't have any probative, persuasive value to the issues that are in the case. Your lie may be one of those issues that was otherwise going to be kept out. But if the lie gets discovered, then all of a sudden it becomes admissible. You've just harmed your own case, potentially ruined your own case unnecessarily. And that's why you shouldn't be telling lies. Not to mention there's a rather human effect. You see, your lawyer is going to want to like you. But if you keep telling him lies, if you keep making his life more difficult, if you persist in things that aren't true, it's going to be harder for that lawyer to work on your case, harder for that lawyer to be motivated to help you when you're not helping him. And that's why lies negatively affect cases, and you shouldn't do it, certainly not to your own lawyer. Well, I'm Matt Hamilton. For additional details on topics like this, I want you to go and seek out my website where we explore them. And if I fail to do that, give me a call at my office. We'd be happy to help you or talk it through. Thank you for joining me. Have a great day.